The hearing opens with the court trying to move cleanly into an agreement, but that momentum breaks the second the mother admits she hasn't fully discussed things with her attorney. That single no changes everything. It signals uncertainty, and in a case like this, uncertainty is dangerous.
Do you solemnly swear or affirm the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
So help me God.
Yes.
Okay, all right, you can put your hand down. Mr. Burns, you heard your attorney said that you have reached an agreement. Is that correct?
I'm Mrs. Burns.
I'm sorry, I said Ms. Burns. All right, let me say again, Ms. Burns. I heard you say that, and your attorney say you've reached an agreement. Is that correct?
Correct.
And Mr. Kohler, have you as well reached an agreement?
Yes, sir.
I'm going to go through the rights that each of you have. These rights apply to both of you, so I'll just do it once, even though your agreements are obviously a little bit different, and I'll have to go through them separately. So, so I will go through each right, and as I do, I would ask first Ms. Burns and then Mr. Kohler if you agree that you're giving up, or you understand you're giving up that right. You don't have to say the same thing. If you don't understand it, want me to explain it again, I'd be happy to do it. But have you each, Ms. Burns, have you had an ample chance to discuss this with your attorney?
No.
Do you want to discuss this further with your attorney?
Yes.
All right. Mr. Delaney, I'm sorry. Yeah, Mr. Delaney, that is your client. Would you like to have a breakout room with your client?
Yeah, there may be a misunderstanding as to what we're doing today, but I can clarify that with her.
Okay, all right. So, ma'am, there will be an invitation coming to a breakout room. Please accept that you and Mr. Delaney can have a private conversation.
Okay.
And Judge, the department will waive the reading of the petition if the other parties will.
All right. Mr. Brown, will you?
Yes, Your Honor.
Mr. Delaney, do you waive the reading of the petition? I think he's left. I'll ask him on his return.
And then Ms. Hansel too, Judge.
While we're at it, Patrick, did you have any other questions?
No, sir.
Okay, thank you.
All right. And Ms. Hansel, do you waive reading of the petition?
Yes, Your Honor.
Okay, thank you. All right, Mr. Delaney is back. Ms. Burns, can you hear me? Is she back yet, Kylie?
She is not, but I'm going to close the room, so she should be soon.
Okay.
Brooke, the foster care caseworker, is trying to join the thing. She just texted me.
Okay. Kylie, if you see her, if you could let her in as well.
I have her coming in right now.
Okay. Ms. Burns, can you hear me?
Yes.
All right, and I know you'll start your video. Okay. Can you hear me now, ma'am?
Yes.
All right, and you had a chance to talk to your attorney?
Yes.
Do you wish to speak to him any further before going ahead?
No.
And is it still your desire to go ahead with the admissions to give the court jurisdiction?
Yes.
All right, let me just go for a quick aside. Mr. Delaney, everybody else has waived the reading of the petition by the court. Do you as well?
Yes, and what he's talking about, Jessica, is we don't need to read the allegations into the record. You know what those are. Is that correct?
Correct.
All right, so do you both understand that you have the right to an attorney? And in fact, you are represented, Ms. Burns, by Mr. Delaney and Mr. Kohler by Mr. Brown. Ms. Burns, do you understand that?
Yes.
And Mr. Kohler, do you understand that?
Yes.
Do you both understand that if the court accepts the plea that's going to be forthcoming, I understand in a few minutes, you'll each be giving up your right to a trial by jury? Do you understand that, Ms. Burns?
Yes.
Do you understand that, Mr. Kohler?
Yes.
And do you each understand that you would be giving up, by the plea, you'd be giving up your right to have the petitioner, Department of Health and Human Services, prove the allegations in the petition by a preponderance of the evidence? Ms. Burns, do you understand that?
Yes.
And Mr. Kohler, do you understand that?
Yes.
And you would each be giving up the right to have witnesses against you to appear and testify under oath and be able to have you or your attorney cross-examine those witnesses? Ms. Burns, you understand you'd be giving up that right?
Yes.
Once
And
the
Mr.
rights are
Kohler?
laid out, the tone shifts from procedural to surgical. Every right mentioned is a piece of leverage the parents are about to give up: trial, witnesses, cross-examination, and forcing the state to prove its case.
And Mr. Kohler, do you understand that you'd also be willing to giving up that right?
Yes, Your Honor.
All right, and you each, right now, you understand you have the right to subpoena any witnesses to a hearing, any favorable witnesses or that you believe would give favorable testimony to you. Ms. Burns, do you understand you'd be giving up that right?
Yes, Your Honor.
And Mr. Kohler, do you as well?
Yes, Your Honor.
And do you understand that one of the consequences of the plea could be that if it was, that it could be later used as evidence in a proceeding to terminate parental rights should such a petition ever be filed? Ms. Burns, do you understand that?
Yes.
And Mr. Kohler, do you understand that?
Yes, Your Honor.
And do you also both understand that if parental rights were subsequently terminated, an obligation to pay child support would continue, excuse me, until a court of competent jurisdiction modifies or terminates the obligation, or an order of adoption is entered, or the child is emancipated by operation of law? Ms. Burns, do you understand that?
Yes.
And Mr. Kohler, do you understand that?
Yes, Your Honor.
There will be some additional questions I will ask you once we go ahead with the plea, assuming that we do it. But I want you both to understand this is completely voluntary. If at any time you said to me, Mr. Referee, I would like to stop this procedure, we would stop it. Ms. Burns, do you understand that?
Yes.
And Mr. Kohler, do you understand that?
Yes, Your Honor.
All right, I am now turning to Ms. Burns' agreement, understanding you're still under oath.
Judge, can you turn on her camera? She
Do I
just,
have to?
Yeah, yes, you do. This
Well-
is, you know, unless there's, oh, go ahead if you would. Thank you. Hold on a minute. I had the wrong document there. All right. All right, here's Ms. Burns' agreement. So this part just applies to Ms. Burns. Ms. Burns, do you well, first of all, as to the children, you are the mother of Elijah Kohler, Ethan Kohler, and Morgan Kohler, is that correct?
No, I am the mother of the two boys, Elijah and Ethan, stepmother to
Okay,
Morgan.
my error, all right. All right, and are you currently a resident of Otsego County?
Yes.
And were you a resident of Otsego County at approximately the time when this petition was filed?
Yes.
All right, and I'm now looking at the petition and the allegations that are being admitted. Is this a reference to the amended petition, council?
Yes, it's a first amended petition, Judge.
All right. So, ma'am, then paragraph 4. Well, I'm not sure if these track. I'm looking at 4A under the mediation agreement. I'm wondering if I'm missing something that looks different from 4A under the amended petition. What I'm going to read is from the mediation agreement. I'm going to assume that that will be satisfactory. Ma'am, is it true that Elijah reported that you and his dad were both drinking Fireballs, and he reported that you drank 2 10-packs of Fireball shooters? Is that true?
Yes.
Is it also true that you and his father got into a fight and that his father left the home?
Yes.
Is it then also true that you got into a fight with Morgan?
Yes.
And who is Morgan?
My stepdaughter.
Okay, how
Patrick
old is
Kohler's
she?
daughter.
Okay, how old is she approximately?
12, 13.
All right. And is it true that Morgan then shut herself into the bedroom and that you tried to enter that room?
Yes.
And is it true that you were pulled out of the room? I'm sorry, that she was pulled out of the room by you and that she shoved you to the floor and started kicking you?
Yes.
All right. I'm turning to paragraph 6, and all the mediation agreement states is just the number and the letter. So counsel, correct me if I'm.
The questioning deepens. The case shifts from broad concerns to specific, damaging details. The mother confirms repeated alcohol use and escalating conflict, while the father starts navigating carefully, choosing words that soften impact without denying the facts entirely.
It's page 7 of the first amended petition, Judge, 6B, C, D, and E. That's also part of the mediation agreement.
All right, okay, page 7, thank you. All right, so 6B, is it true that you drink Fireballs daily?
Yes.
And is it true that you and Patrick got into an argument the following evening and he left the home?
Yes.
And is it true that you reported that Morgan is mouthy and after Patrick left the home, you and Morgan got into a verbal argument?
Yes.
And is it also true that you reported that Morgan went into the bedroom and called the police because Morgan knew that you had a warrant for her arrest?
For my arrest, yes.
Okay.
Judge, can we also, 6 also references a date of October 22nd of 2025, and Miss Sullivan was interviewing Miss Burns, and those were how she responded to Miss Sullivan's questions.
All right. And is that an accurate statement then, Ms. Burns?
Yes.
All right. So Mr. Sommerfeld and Mr. Delaney and Ms. Hansel, have I covered the agreement in full involving Ms. Burns?
Judge, I would just reference, we need to get the children are domiciled in Otsego County. Also, that was in the mediation agreement, and how old her 2 children are to show that they're under 18.
All right, thank you. So Ms. Burns, your 2 children that you mentioned that are yours, that are subject to this, the 2 boys, are they residents of Otsego County?
Not at the moment.
Okay, but were they when this incident happened?
Yes.
And how old were they when this incident happened?
10 and 9.
All right, Mr. Sommerfeld, do you believe that I have covered the entire mediation agreement?
Yeah, and that's it was, I'm sorry, it was Elijah and Ethan.
Right, she had mentioned that earlier, correct?
All right, thank you.
Okay. All right, Mr. Delaney, do you also agree that the agreement has been fully placed on the record?
I do agree, thank you.
And Ms. Hansel, do you agree as well?
I do.
All right, and Ms. Burns, asking you now, do you wish the court to accept your admission and to take jurisdiction over the children, over your two children through you?
Yes.
All right, you have certain appellate rights that I'm going to go through after I complete Mr. Kohler's portion of this, so. All right, Mr. Kohler, you understand that this is a completely voluntary proceeding, and if you decided at any time you wanted to stop it, all you had to do is let me know and I would stop it. Do you understand that?
Yes, Your Honor.
All right, and which minor children are you the father of?
Ethan Kohler, Elijah Kohler, and Morgan Kohler.
All right, and were all of them residents of Otsego County at the time of these incidents?
Yes, Your Honor.
All right, and were all of them under the, well, why don't you just tell me what their ages were?
9, 10, and 12.
All right. So paragraph 1. Do you understand that Ms. Sullivan of the agency made contact, face-to-face contact with Ethan?
Yes, Your Honor.
And do you understand, is it true that Ethan reported to her that he thought the worker, that she was there to see him due to an incident that had happened the previous evening in the home?
Yes, Your Honor.
And did he report that the previous evening, his mom and dad, you being his dad, were drinking and got into a fight, that his mom hit you with a crowbar, that you report you witnessed her hit you with a crowbar? Is that, do you understand that as well?
Yes, I understand that.
All right, did Ethan report that his parents drink bull shots? I'm not quite sure what a bull shot is, but daily, is that correct?
Yes.
And is that an alcoholic drink?
Yes, it is, Your Honor.
Did Ethan report that his parents often got into physical assaultive fights with each other while they were drinking alcohol?
I'm not sure, but yeah, sure. Yeah. Yes, Your Honor.
Well, we can't do that. We can't do it that way. Do you believe that Ms. Sullivan's statement is accurate, that Ethan reported to her that his parents, which would include you, often got into physical fights with each other while they were drinking alcohol?
Yes, Your Honor.
All right. Then I think we turn next to paragraph 4.
This section quietly becomes the most damaging for the father. His own apology to the children turns into evidence of poor judgment. By admitting he wouldn't have left them if he knew how intoxicated the situation was, he confirms awareness of risk. Just too late.
On October 22nd, 2025, is it true that Elijah reported the previous evening his mom and dad were both drinking Fireballs, and Elijah reported that, well, his mom drank 2 10-packs of Fireball shooters? Is that true?
Yes, Your Honor.
Is it also true that you and Ms. Burns got into a fight because Ms. Burns wanted to, quote, do inappropriate things and you did not?
I would define it as an argument, not a physical fight. But yes, Your Honor.
All right, I'm going to go back to that with counsel in case there's anything else, just to make sure you're still satisfied with the plea. But did Elijah report that you then left the home?
Yes, Your Honor.
All right. Did Ms. Burns start a fight with Morgan and told Morgan that she was going to effing kill her?
I wasn't here.
Okay, I can understand that. All right. I'm just looking down. Do you know if they spent the night with their uncle Justin?
Yes, Your Honor.
All right. And is it true then that you picked them up from their Uncle Justin's home in the next morning to take them to the bus stop, and that on the way to the bus stop, you apologized to all the kids, telling them that if you had realized how drunk their mom was, you would have not have left them at home with her? Is that true?
Yes, Your Honor.
All right, as to paragraph 5, is it true that on or about November 24th, 2025, the school informed Child Protective Services worker Ann Sullivan that Ethan was struggling during the school day by making disturbing comments regarding his mental health? The school reported having difficulty reaching you by phone. Once you were reached, you came to the school and stated you would keep Ethan at home for a few days to keep him safe. You opted not to take Ethan to the emergency room for a mental health evaluation, as was recommended by the school counselor. Is that true?
Yes, Your Honor.
And is it also true that on November 24th, 2025 at 11:45 p.m., while Jessica and Cole were at your house, you and Cole got into a physical altercation with each other? That Patrick, Jessica, and Cole were under the influence of alcohol at the time, and that Ethan witnessed that altercation?
Yes, Your Honor.
And is it also true that Jessica has been at your home on a few occasions?
Yes, Your Honor.
All right, Mr. Summerfeld, I know on at least one instance, the language that Mr. Kohler used was a little bit different than what is in the mediation agreement. On the other instance, he said, I wasn't in the home because he had earlier said he had left. Are you satisfied with the agreement that is on the record?
Yes, Judge. Also, we need to address, there's 2 other children here. They have also, we have to clarify that.
Well, let's do that. Let's finish this up with Mr. Kohler first, and then we can get to that. But are you satisfied with the agreement as to Mr. Kohler?
Yes.
Mr. Brown, are you?
Yes.
And Ms. Hansel, are you?
Yes.
All right, and Mr. Kohler, you understand if I adopt this agreement, then the court will be accepting jurisdiction over your children through you, and you will be giving up those rights that I enumerated earlier. Do you understand that?
Yes, Your Honor.
Now, you and Ms. Burns have certain appellate rights that I'm going to go through, but Mr. Summerfeld, I want to go back to the question that you raised. I'm not quite sure I understand it. Could you tell me that again, please?
Well, we have Mia McMurphy and Kylie McMurphy.
Whose children are they?
Says Jonathan McMurphy, he's not a respondent, is the legal father.
Right.
But isn't Miss Burns the mother of those children, or Brianna Ralston is the mother?
I am.
Okay.
So you are the mother of, I'm sorry, Jessica Burns, you are the mother of Mia and Kylie as well?
Yes.
All right. You understand that the rights I enumerated would refer to them as well. In other words, that the court accepts this plea, that the court will have jurisdiction over Mia and Kylie as well.
Yes.
All right. And is that your desire to proceed in that manner?
Yes.
The clarification about the additional children exposes how fragile these proceedings can be if details are missed. The mother initially limits her role, then has to correct herself, and that correction expands the entire scope of the case.
All right. And once again, Mr. Kohler, you are not the father of those 2 children. Is that correct?
That's correct, Your Honor.
All right. I'm going to be, go ahead, Mr. Summerfield. Anything else?
No, were they living with both Mr. Kohler and Miss Burns when the allegations that they pled to, were they in the house?
No.
They were.
Mr. Kohler, were they?
No, sir.
All right. Does that change the posture of the case, counsel?
I don't know. Can I have a breakout room with Miss Sullivan?
All right, Mr. Sommerfeld? I think you're muted. I can only see a silhouette of you.
I'm sorry, Judge. So you didn't hear what I said earlier either. So, no, in the beginning of the plea, Mom said she was the mother of Elijah and Ethan. She's also the mother of Mia and Kylie McMurphy. I want to make that clear as it relates to her plea. Those children were not present. However, based upon the things that Mom has pled to regarding the other children, it would apply. How you treat one child could be used in how you would treat other children.
Right, and I did ask her that question once that was brought to my attention, that she understood that the plea would be part of the other two children would be part of the plea as well, and she acknowledged that.
Yeah, I want her to acknowledge that she's also the mother of those two kids, just because it conflicts with what she said in the beginning.
All right, I think she later changed. It's probably a bad question on my part, but ma'am, do you agree that you are also the mother of those two children?
Yes.
The two McMurphy children?
Yes.
Okay, all right. All right. The court is satisfied by a preponderance of the evidence that the agency has met its burden through the admissions of both parents, specifically as to under MCL 712A 2B, that the parent, and this would refer to both parents, when able to do so, neglected or refused to provide proper care or necessary support, education, medical, surgical, or other care necessary for their health or morals, or subjected them to a substantial risk of harm to their mental well-being. And also the following subparagraph, that the home or environment, by reason of neglect, cruelty, drunkenness, criminality, or depravity on the part of a parent, guardian, non-parent, adult, or other custodian, it was an unfit place for the children to live. Both of those subsections have been satisfied as to all children to both parents by preponderance of the evidence in the court's estimation. And the court does find that the pleas were freely, voluntarily, and knowingly made, and the appellate rights that attach and that are applicable to both parents. I'd ask you to both listen, because I'm then going to inquire if you understand these, but that appellate review is available to both of you to challenge any errors in the adjudicatory process, which may be challenged in an appeal apart from the court's initial order of disposition. That as an indigent respondent, which you both are, I believe at this point, you're entitled to the appointment of an attorney to represent you in any appeal, as well as the right to and preparation of transcripts and supporting documents without cost, and that you may be barred from challenging the assumption of jurisdiction in an appeal from an order terminating parental rights if you do not timely file an appeal of the initial dispositional order under the Michigan court rule, or delay appeal also under the court rule. Ms. Burns, do you understand you understand those appellate rights?
Yes, Your Honor.
Okay, and Mr. Kohler, do you also understand those appellate rights?
Yes, Your Honor.
All right, Mr. Sommerfeld, anything else that we can do on this matter at this time?
No, thank you, Judge.
All right, Mr. Brown, same question for you.
No, Your Honor, thank you.
Mr. Delaney, same question for you.
Nothing further. I just want to indicate to Jessica, the next hearing will be about putting together the plan that we're following now regarding the children. So there'll be another hearing at a future date. Does that make sense to you?
Yes.
Okay, thank you. That's it, Judge.
All right, thank you. Ms. Hansel, anything further from you?
No, sir.
How are the children doing?
They're doing well. They're doing well.
All right. Okay, all right. Okay, and you can give a greater report, of course, when we get to disposition and we see where things are. All right, there being nothing further, and I know this took a long time both today and to get this to this place, but it's important to be thorough and to make sure that everybody's rights are protected.
The judge's final ruling locks everything into place. By accepting the admissions, the court formally declares the environment unsafe and establishes jurisdiction over the children. The language used, neglect, risk of harm, unfit home, is deliberate and powerful. It transforms personal conflict into legal grounds for state intervention. From this point forward, the burden shifts. The parents are no longer just defending themselves, they must now prove change. The appeal rights explanation sounds routine, but it's actually a warning. If they don't act within the rules, they may lose the chance to challenge this decision later. The closing remarks feel calm, but the reality is already set. The case has moved past questioning. Now it enters enforcement, planning, and long-term scrutiny.